Today's case is one of frustration, second chances, and tough justice. Meet Devon Keith Barley, a man already on probation for violating protective orders, now facing new charges for assault and drug possession, all while still under supervision. The courtroom is tense. The judge's patience is wearing thin, and the probation officer's tone says it all. They've tried everything to help him. But when a defendant racks up new offenses, failed drug tests, and a crack pipe charge, mercy starts running out fast.
Good morning, sir. Are you Devon Keith Barley? And Mr. Barley has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800 on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Obviously, I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Barley. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Barley, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're...
Right away, the judge clarifies the allegations, multiple violations stacked together: assault, opiates, alcohol, cocaine, and failure to attend treatment. That's 5 strikes while on probation. For context, a probation violation means breaking the terms that kept him out of prison in the first place. When those violations involve violence and drugs, judges have very little wiggle room. What's wild is that Barley's defense is already trying to get bond, but with new offenses on top of old ones. That's like asking for trust after setting fire to it.
Allegations, and obviously they haven't been proven true, but it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at another location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing without the full team.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's done an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Now the state steps in, and they're clearly done playing nice. They confirm to new offenses while on bond, and even hint at possession of crack cocaine. The prosecutor reminds everyone this isn't Barley's first time slipping up. It's a pattern. That's the key word here, pattern. In probation law, 1 or 2 slip-ups can be managed, but a string of new crimes signals defiance, not rehabilitation. Viewers, here's a question. At what point does helping someone become enabling? Should courts keep giving chances to people who keep wasting them?
Can I have?
You may. Go ahead.
Can I ask her a question? When did you place it on JCDI? Do you have a date? When was you actually placed it? Was it 2019?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His intake went up. We've done on multiple occasions. He's tested positive for cocaine on multiple occasions, and we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we've got him being in front of a counselor, him getting that drug treatment is what he needed. He agreed with us that's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDI?
He did. Tested positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, it wasn't him not going?
As well as the drug use.
And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is the interest.
This part gets real. The probation officer lays it all out. Every failed program, every missed opportunity. They put him in ISF cognitive, MRT, JCDI, and even gave him therapy for substance abuse. That's the full rehab lineup. But Barley admits to using again and even drinking while in treatment. The officer's tone says it all. We've tried everything. That's the moment you realize this isn't just a legal breakdown. It's a human one. The system's out of tools, and all that's left is accountability.
Facility that we send people to about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024. All right, anything else, Mr. Burbank?
Mr. Barley, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If it was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer that I would like to get into an outpatient program at rate choice if possible, which will allow me to, I just told you I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, it is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
would go.
as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
You had a stroke last year?
Yes, sir.
And you're still testing positive for drugs after having a stroke. Okay, all right.
Do you have a place to stay?
Yes, I do.
And where is that?
It was apartments, on Mosaic Apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, Latoya Barley, also my mother.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Cross, in Fraser.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got 2 kids here in Beaumont. And one that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Barley, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing? What guarantees?
I would accept that offer of the batch. That I would guarantee. I just want to get back to work. What I do, we don't just go to work and come home.
Oh, you do other things. You've done other things.
Yes, I have.
So
Now Barley speaks, and his story takes a turn. He talks about wanting to work, about having a stroke, about family and rebuilding. It's emotional and sincere on the surface, until the judge cuts through with a single question. You had a stroke, and you're still testing positive for drugs? That question hits like a hammer. The judge's disbelief mirrors what many people watching are thinking. If near death didn't change you, what will? This moment perfectly captures that line between empathy and exasperation.
what's the guarantee that says you're not going to do those other things when you're doing work and going home?
Yes, and I see this as my last opportunity to keep everything that I have in my house.
One of the things is that you tested positive. What date was that, Your Honor?
I don't know, Mr. Burbank. What date is it?
Now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go ahead.
April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes, yes.
Yeah, there was. So those allegations are true, correct? If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled. We're not sworn in, or if he wants to plead to the motion, we can take care of that. With regard to the bond, allegations, at least for that new offense on May 29th of this year, is that approximately 3:00 in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's to think that you're out possibly driving in the middle of the night, either finding drugs in the wrong area after. This is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with.
And just when you think it can't get worse, the facts drop. Barley admits he tested positive for both alcohol and cocaine while on probation. The prosecution doesn't even need to argue. These aren't rumors. He admits it himself. And then comes the kicker, the new arrest. 3 a.m., parked in an area known for drugs and prostitution, with crack and a pipe allegedly in the car. The judge doesn't even hide her reaction. Disappointment, exhaustion, and concern for public safety all at once.
With JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them, let's work with them, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If depending on what the plea is on the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
I'm advising not to enter a plea in reference to the new offenses until we know exactly exactly what it is on the
That's fine.
assault.
I think we can get that taken care of, if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Barley, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let me get this pulled up a different way. I think I can do it. So, will he waive the formal reading of the motion?
You will, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Barley, in 1828,
At this point, the judge makes it official, no bond. She details how probation gave Barley 5 separate administrative chances before even coming back to court. That's 5 lifelines, each one ignored. The irony? He's still asking for another chance for outpatient treatment while sitting there for being arrested during the last one. The judge's voice is calm but final. It's not anger, it's clarity. Sometimes the system's compassion becomes the very thing it can't afford anymore.
800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 1829063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, 3rd-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates. And is that true or not true? Count 3 alleges in each case that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged. So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
Not true.
Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that. We can get that expedited. All right, we'll see y'all back at sentencing. Yes, sir, thank you.
By the end, Judge Raquel West resets the case for sentencing, ordering a full pre-sentence investigation. Translation: the system's giving him one final review, not mercy, but due process. This entire hearing shows a courtroom balancing empathy with responsibility. Devon Barley's case reminds us, probation is a privilege, not a loophole. Every test failed and every offense committed chips away at that privilege until it's gone. If you found this hearing as gripping as we did, make sure to like, share, and subscribe for more real courtroom breakdowns. Drop a comment below. Do you think the judge made the right call denying bond, or should he have been given one last chance at redemption?